got it? Grab a seat.
Good afternoon. Welcome everyone to this momentous day in the Penn Law School life, to our symposium recognizing the 25th anniversary of the appointment of Justice Ruth Bader Ginsburg to the U.S. Supreme Court. I'm Ted Ruger, the Dean of Penn Law School. Happy to be partnering in this enterprise with the National Constitution Center and Jeff Rosen, who's in the audience. Justice Ginsburg, we are so proud and happy to have you with us here today and this evening. Your visit provides an opportunity to reflect on your immense impact on American law over the past several decades. In signaling this as 25 years on the court, it is indeed a call for celebration, but in many ways that actually understates your tremendous influence of your career, given your path-breaking work before you were a Supreme Court justice as a legal scholar, as an impactful litigator for equality and other causes, and as a lower court judge. We're so happy to have you with us today to celebrate your life of leadership in the law. It takes a distinguished panel of many to celebrate such a distinguished career, and so we're fortunate to have a very stellar panel of guests assembled today to discuss the lasting impacts of Justice Ginsburg's work and the influence that the justice has had on the careers of many of our distinguished panelists. I'll introduce them together, and then they'll speak in turn. First, we have Marcia Greenberger, who was the founder and co-president of the National Women's Law Center, and a longtime advocate for impactful legal equality and justice in the workplace and other settings. We're very proud to say that she's a Penn Law graduate, and welcome back to your alma mater. Next, we have a Penn Law faculty member, our own Professor Serena Mayeri, who's a professor of law and history here at the University of Pennsylvania, an expert on the history of equality litigation before the Supreme Court and in other venues over the past half-century. Her current project investigates the history of the legal primacy and legal construction of marriage and touches on much of the work done by Justice Ginsburg when the justice led the ACLU's Women's Rights Project. Professor Mayeri. Next, we have the Honorable John Owens of the U.S. Court of Appeals for the Ninth Circuit. He's currently a judge in San Diego on the Ninth Circuit. Before that, served as an assistant U.S. attorney in both San Diego and Los Angeles. He also was a clerk for Justice Ginsburg the same year that I spent clerking for Justice Breyer. I can say that Judge Owens was and is a much better basketball player than I was, and indeed, he was. I think the judge would agree. He was the second best basketball player in that cohort of
not the
of
best.
Clerks.
Sri Srinivas
Yes.
on D.C. Circuit, the best.
Yes. So welcome, Judge Owens. Another leading federal judge, the Honorable Jed Rakoff, a senior judge on the U.S. District Court for the Southern District of New York, long a leading judicial authority on issues like securities law, white-collar crime, and a leading figure in the effort to reform our criminal justice system. Judge Rakoff is also a native of Philadelphia. So welcome back, Judge.
But I can't play basketball at all.
Finally, Dahlia Lithwick, one of the leading journalists of the Supreme Court, working over the past decade or two. She's a senior editor at Slate, writes extensively about courts and legal issues, hosts the podcast Amicus, which is a show about the law and workings of the Supreme Court. Welcome, Dahlia. Yeah. So we'll begin our discussion. The Justice will offer some responsive remarks, and then we have a few students who will ask questions after our panelists. Thank you.
I think I'm up first. So thank you very much, Dean Ruger. And I just words fail in expressing how absolutely grateful I am and what a privilege it is to be here today to participate in this important discussion with such an extraordinary panel, and to be a part of it with Justice Ginsburg is really what makes it beyond words. And I want to tell you all as well, having it at Penn Law makes it all the more special. I owe my career and my husband to Penn Law. We bonded in our first year over torts. And we had then Professor Clarence Morris, very renowned, both for his scholarship and for his perfection of the Socratic method. And also, for those who may not know, he was the contributor of The Goat. So that was all a sense of extraordinary gratitude to be here. Well, in thinking about Justice Ginsburg's impact on women's legal rights, there is no way really of understating it. When I started to work on women's rights as an advocate in 1972, I went to one of the first public interest law firms, the Center for Law and Social Policy, to start a women's rights project. It was the all-female administrative staff at the center that got the idea that the center should work on women's rights, and they got the idea from the landmark work that already was being done by then advocate Ruth Bader Ginsburg in New York at the ACLU and in the Rutgers Law School in Columbia, of course, as well. I was not alone. There are women's advocates all over the country who were beginning equal rights advocates in San Francisco, other organizations, strong organizations, who modeled themselves and their strategies and their arguments on the pioneering work of Justice Ginsburg. She taught us that litigation, of course, is an essential tool. So is legislative advocacy and advocacy before the executive branch, and underlying all of that must be public education and having the public with you. Lessons that are as true today as they've ever been. And now, as a Supreme Court Justice, as we know, for 25 years about, her impact on the public, its understanding of the law and the law, both in constitutional and statutory spheres, has just been enormous. On a beautiful sunny day in June 1993, in the Rose Garden, President Clinton announced her nomination to the Supreme Court. He described his reasoning for selecting her as based on 3 factors. I will tell you, having had the honor of being in that Rose Garden ceremony, attending it at that time, that everybody was very interested in what President Clinton had to say, but there was not a dry eye in the place when then Judge Ginsburg got up to speak. His reasoning was based on 3 factors. 1, her distinguished record on the DC Circuit for 13 years. 2, and this part is particularly meaningful to me, her historic and pioneering work on behalf of women in the finest tradition of law and citizenship. And 3rd, his confidence that she would be a force for fidelity to the Constitution, and how right he was. Justice Ginsburg has been distinguished, of course, in bringing her life experiences to the court, as well as her brilliance and respect for the law. And that is what was including some of the themes that she struck on that beautiful June day. Her life as a daughter whose parents had recent immigrant roots, a wife, a mother, a path-breaking student, employee, and legal advocate. She faced discrimination based on her gender and her religion and her economic struggles. She understood intersectionality to her core from her earliest days. And her jurisprudence reflects that core understanding, reflecting women's diversity in background and circumstances. Okay, my time is coming up, and I haven't even gotten to much of what I wanted to cover. Unfortunately, Professor will take off from me, but let me say a couple quick things. Of course, her Brandeis brief in Reed v. Reed in 1971 was not only the landmark filing that led to the first time the Supreme Court ever struck down any statute on the basis of sex discrimination, but it also was the roadmap not only for her work, but for others all around the country. 2, by 1976, when the Supreme Court in Craig v. Boren officially recognized heightened scrutiny for sex discrimination under the Constitution, they did so based on many of her cases that she had brought. 3, those cases that she brought were sequenced, briefed, and argued by her in a brilliant way that also became a model for the success that she experienced and for advocates to learn from going forward. Let me fast forward 20 years to 1996, when litigator Ginsburg became Justice Ginsburg and had authored the majority opinion in U.S. v. Virginia, the VMI case. It established and put meat behind this heightened scrutiny standard. Time doesn't allow me to describe all of the elements in it, but it is that standard that we operate from to this day. I want to make a couple quick points. One, that it is this standard that has prevented the government from excluding men or women from opportunities and from reaching their potential and from securing their due based on arbitrary assumptions and generalizations as to what men or women should or must or can do. But this standard has also had an enormous impact in legislative authorization for the federal government to be able to address this discrimination, and I will point just to the Family Medical Leave Act, where the Supreme Court authorized an aspect of the Family Medical Leave Act applying to the states because of the heightened scrutiny that the court had recognized through Justice Ginsburg's work. And of course, that heightened scrutiny has been the basis of other statutes that Congress has enacted, such as Title IX, and other statutes as well, more recently. That VMI case was argued by Paul Bender on behalf of the government. He was the principal deputy SG, Solicitor General at the time. I had had him as my con law professor at Penn. One of the points he made in the oral argument was that VMI's fervent argument that women would ruin VMI, destroy it for the men, and that they couldn't handle the Spartan adversative teaching method that VMI prided itself on, and as one expert I remember to this day testified very, very, in the lower court, very solemnly, women would break down and cry. So you couldn't subject them to that. My professor, Paul Bender, although he, of course, had other titles in life after that, compared that kind of resistance to the way some people had thought about women in law school, that they couldn't take it if they were subjected to the Socratic method. An analogy that rung especially true to me, but I thought probably spoke to those justices as well. In any event, it is a strong standard. It has made a huge difference both in statutes that have been passed as well as constitutional protection. And I want to conclude with 2 quick points. One, that Justice Ginsburg's dissents have often been as powerful and impactful as have been her decisions. And I will pick only one example, the Ledbetter case involving Lily Ledbetter at Goodyear Tire, Gadsden, Alabama, a place that's been in the news relatively recently, where she was a manager and held a job that was mostly held by men. After working there and working her heart out for 20 years, she found out through an anonymous note that she was paid less than every male who held that job, including the young men who she trained. She filed suit. She was close to retirement. She needed that money. Her Social Security was lower because of it. All of the accumulated raises were lower because of it. The majority of the Supreme Court held because she didn't file her complaint within 180 days of the first discriminatory paycheck that she got. 6 months after she was hired, she was barred from ever complaining up until the last discriminatory paycheck, which she had filed. And Goodyear was home free for as long as she worked there, for never having to pay her equally. Justice Ginsburg understood this was no technical decision about numbers of days in filing, which is the way many people saw that case. And I can tell you, we spoke to the press until we were blue in the face and others trying to explain this is not a technical case. We needed Justice Ginsburg's dissent, and she read it from the bench. As a result, the Supreme Court press got it in a way they didn't get it from some of these advocates, as embarrassed as I am to admit it to you. And they covered it. The wider press covered it. That public education that she understood that was so important even reached Congress because the public got it. It also reached the presidential election that was going on, and it became the subject of debate in the election and even advertisements. It was passed overwhelmingly by Congress after the elections, and it was the first law that President Obama, the Lilly Ledbetter Fair Pay Act, signed. And I will tell you that I brought Lilly Ledbetter to meet her hero in her chambers. And anyone who has the good fortune to meet Justice Ginsburg knows what an extraordinary and kind and generous human being she is. And she was willing to allow Lilly Ledbetter to meet her, and it was an experience that none of us will forget. Well, there have been some dissents that Justice Ginsburg has authored that advocates have not been so successful in being able to bring to fruition and correct. And some of them deal with sexual harassment, for example, and weakening the laws of sexual harassment. But I will tell you this. She continues, as she has in those cases, to give a roadmap about what is the rationale for those corrections, what they should be, the arguments, and I have every confidence that the time will come when they will be made. They were made in the General Electric case when she was an advocate, when General Electric covered every health condition for their disability plan, as well as their health plan, among other things, except pregnancy, even complications of pregnancy. Then Advocate Ginsburg chaired the coalition to pass the Pregnancy Discrimination Act, which she did. So it is incumbent upon all of us who will not be on the bench to watch for her majority opinions as well as her dissents. They will be a blueprint for those that she has already issued as well as those yet to come, to give us our marching orders for the work that needs to be done in the future. Thank you.
Is this working? Can you hear me? Just a footnote about the VMI case. We celebrated not too long ago the 20th anniversary of the decision. The General invited me very enthusiastically to come and see how the women are doing. And they are doing just great. The VMI is very proud of its women cadets. They enabled the school to upgrade its applicant pool tremendously. There are now women on the faculty, on the Board of Trustees. They had a rocky start. They said there would be no concessions for the women. They would be treated just like the men. And that meant when they entered, their heads were shaved. Well, VMI today is a bit more flexible. The women no longer need to shave their heads. Most of them were engineering students. That was heartening for me because when I went to college, there was only one woman in the engineering school. So VMI has been a great success story, and I'm delighted to have been a small part of that.
20 years ago, we were invited by the then superintendent to come down and see VMI. And he called and asked me if I would come and bring some colleagues so I could see for myself how impossible it would be to have women at VMI. What a clear-cut example of the revolution that Justice Ginsburg has wrought.
Well, like Marcia Greenberger, I feel it's impossible to put into words what an honor it is to be part of this distinguished panel celebrating Justice Ginsburg. I wanted to use my time today to trace three themes that link Justice Ginsburg's earlier career as an advocate to her jurisprudence of equality on the Supreme Court. First, as an advocate and on the bench, Justice Ginsburg has promoted a theory of equal citizenship that intertwines racial and gender equality, expanding our conception of both. The 14th Amendment litigation strategy that Marcia Greenberger just described has roots in a memorandum prepared by a pioneering civil rights lawyer named Polly Murray in 1962. Murray believed that fighting race and sex discrimination simultaneously could bridge divides among feminists and forge a coalition between movements for racial justice and for women's rights. And she hoped that a particular challenge by a woman named Gardenia White to Alabama's exclusion of African-American men and all women from jury service would be Women's Brown versus the Board of Education. Enter professor and advocate Ruth Bader Ginsburg, who picked up Murray's torch in the early 1970s. She fought for women like Edna Stubblefield, a 19-year-old African-American woman convicted of murder by an all-white, all-male Tennessee jury. And by 1975, Attorney Ginsburg had persuaded the Supreme Court to overrule Hoyt versus Florida, in which Justice Harlan had famously, or infamously, declared that women were the center of home and family life, which justified their exemption or exclusion from jury service. Fittingly, one of the first cases Justice Ginsburg considered on the court was J.E.B. versus Alabama, decades later, which prohibited gender-based peremptory challenges as a violation of equal protection. Justice Ginsburg's affirmative action jurisprudence, too, harkens back to her creative advocacy. In a little-noticed 1977 opinion that bore the marks of her influence, the Supreme Court articulated a distinction between classifications that harmed women, on the one hand, and those that were purposely enacted to compensate for past discrimination against women. Reversing this usual race-to-sex analogy, Advocate Ginsburg argued for the application of this distinction between harmful and compensatory classifications to race-based affirmative action. And on the bench, she has continued to defend carefully formulated policies designed to further racial justice, declaring that actions designed to burden groups long denied full citizenship status are not sensibly ranked with measures taken to hasten the day when discrimination and its after effects have been extirpated. Now to the second theme. As an advocate and a judge, Justice Ginsburg has argued that women's ability to control their reproductive lives, free from constraints imposed by employers or by the government, is central to gender equality. Advocate Ginsburg's crusade for reproductive rights and against pregnancy discrimination began in 1970 with Captain Susan Struck, an Air Force nurse forced by military policy to choose between terminating her pregnancy and ending her military service. Captain Struck, who was Catholic, chose to give birth and place her baby for adoption. Attorney Ginsburg argued that the Air Force could not, consistent with equal protection and religious freedom guarantees, mandate that service women be discharged for pregnancy. Captain Struck's case never reached the Supreme Court, and the quest for reproductive control and for freedom from pregnancy-based discrimination met with daunting obstacles, often necessitating the kind of legislative action that Marcia Greenberger just described. But having long argued that equal protection and gender equality provide the most solid constitutional foundation for reproductive rights, Justice Ginsburg's powerful dissent in Gonzalez versus Carhart, another one of these dissents, linked reproductive freedom not to a generalized notion of privacy, but rather to a woman's autonomy to determine her life's course and thus to enjoy equal citizenship stature. The final theme. As an advocate and on the bench, Justice Ginsburg has promoted gender egalitarian relationships and shared parenting in ways that reverberate throughout constitutional equality jurisprudence today. As an advocate, she persuaded the Supreme Court that government could not presume a male breadwinner, female homemaker family structure, and thereby penalize women and men who stepped outside these traditional roles. She argued Frontiero versus Richardson, the challenge by Air Force Lieutenant Sharon Frontiero and her husband Joseph to a policy that automatically afforded housing and health benefits to the wives of servicemen, but not to husbands if they couldn't show that they were dependent on their wives for more than half their income. Weinberger versus Wiesenfeld drove this point home. Paula Wiesenfeld, a school teacher and primary breadwinner, died tragically while giving birth. Her husband, Stephen, wanted very much to care for baby Jason himself, but was ineligible for widow's survivor's benefits because he was a man. Persuaded by Professor Ginsburg, Justice Brennan wrote for the majority that gender-based classifications could not be used to justify the denigration of women who do work, and whose earnings contribute significantly to their family's support. Notably, he also embraced the importance of fathers as caregivers, writing that it is no less important for a child to be cared for by its sole surviving parent when that parent is male. By the 21st century, even former skeptics like Chief Justice William Rehnquist were persuaded. Justice Rehnquist had dissented from many of the court's 1970s sex discrimination rulings, but in Nevada versus Hibbs, he wrote the majority opinion, upholding the Family and Medical Leave Act as attacking the formerly state-sanctioned stereotype that only women are responsible for family caregiving. Justice Ginsburg's vision of gender egalitarian marriage also informed the court's majority opinion in Obergefell versus Hodges, where Justice Kennedy cited her famous Reed grandmother brief and the equal protection jurisprudence produced by Advocate Ginsburg to underscore how, quote, the Equal Protection Clause can help to identify and correct inequalities in the institution of marriage, vindicating precepts of liberty and equality under the Constitution. And the new awareness to which Justice Kennedy's opinion refers, of course, was largely the product of feminist advocacy in and outside of court. And finally, Justice Ginsburg's recent opinion in Sessions versus Morales-Santana extends the importance of egalitarian parenting and caregiving relationships beyond marriage to include unmarried parents. She wrote that requiring longer residency for unmarried U.S. citizen fathers than for similarly situated mothers was a, quote, stunningly anachronistic violation of equal protection because it assumed that unmarried fathers would not establish strong and caring relationships with their children. No one has done more than Justice Ginsburg over the past half-century to make such discrimination against women and men, in her words, stunningly anachronistic. Thank you.
Thank you for that wonderful presentation, how you got all that into 10 minutes. I want to just comment on a person that you mentioned, Paulie Murray. When Marcia and I were in the equal rights advocacy business, we were standing on the shoulders of some very brave women who were saying exactly the same thing we were saying a generation earlier when society was not yet ready to listen. And Paulie Murray was one of those people. Paulie wrote an article that was tremendously influential to me. It was entitled Jane Crow and the Law. And it listed all the laws, all the ways women were disadvantaged by the law. Paulie had gone to Howard Law School in the 1940s. She was responsible for desegregating all the area restaurants. This was years before the sit-ins of the 60s. You can read about her in two fine books. One is called The Firebrand, that's Paulie is the firebrand, and the First Lady Eleanor Roosevelt, the friendship between those two women. And the other is called Jane Crow. She was an inspiration. She was a feisty woman. And at last, she's getting the attention that she deserves.
Well, first I want to thank the University of Pennsylvania Law School for putting on this event. This is a very special person over here I'm going to be speaking about, and thank you, Dean Ruger, for inviting me to speak here. Ted, as I know him, or Dean Ruger, he wanted me to talk about some of the life lessons that I learned as a law clerk for the justice. And I think the first one is very important. It's this: marry someone who can cook. Because she's a very special, very, very capable person. But everyone has their limits. Everyone has their limits. No, we all know that the cook of her life was the love of her life, Marty Ginsburg. And I just want to just point out, many people have said this, but I can say this as a 25-year-old guy dating a young woman who was a lawyer at the time as well. There really was no better role model for someone to see how, in that position, a man should act in a relationship. Really was a special. I was very fortunate to have benefited from that. So I got both the Justice and Marty. So I'm always very happy about that. And when you think about the Justice, we know her as the notorious RBG, right? But don't forget, you know, when understanding where she is today, there's always homeboy Marty G. He was a really, really special guy. So, lessons about being a judge. Well, reminds me early on in my clerkship for the Justice, and one of the jobs as a law clerk is you're supposed to express your views on a case to a point. There comes a point where enough has been said. And I remember one case in which I, as a 25-year-old law clerk, was very sure I was right. And I mentioned that a couple times to the Justice, and she was very polite, very good. And then one time we were on the phone, thankfully on the phone, and I said this again, and she said, "That's great, John." Pause. "But I'm the Justice." Pause. "And you're not." So when she said this to me, of course, I was like, oh, man, she really put me in my place. And I'm sure that was part of it. I'm sure that's what it was. But I don't think I fully appreciated what she was really trying to tell me until I got this job. And what she was telling me is that the buck stops with her. At the end of the day, she's the one the president nominated. She's the one that the Senate confirmed. She has to feel comfortable with the decision that either she's signing on to or the dissent she's giving. And especially at the Supreme Court level, that's a big responsibility. And I will say this, I have never met someone who tries so hard to get to that right answer. And I'll give you an example. So just a few years ago, I became a judge myself. Wow, right? And in fact, I think we have, just to give you an idea, that's how I looked back then. All right? So she looks the same. I won't say anything more than that. But anyway, so that's what it was 20 years ago, Justice. And then I became a judge. And there was my first case I ever worked on involved a doctrine called the Taylor analysis. It has to do with when certain criminal convictions can trigger either removal from the United States or enhanced criminal penalties. And I've always thought this area of the law was, I'm sure it's great, but as a prosecutor and as a judge, I thought it was a mess, right? And I wanted to say that. Now I'm a judge, maybe someone will actually listen to what I say. But I said, well, you know, I'm brand new on this job, and you know, maybe I need to show I can actually screw in a light bulb before I shoot for the moon. So I drafted something, but I never filed it. I just never did anything with it. About 6 months later, and to this day, I don't know why I did this, I sent it to the Justice. And she immediately fires back. And I'm paraphrasing here, but she basically said, John, you could never do that again. If you have spent the time to think through an issue and you think something should be changed in the law, you have the duty to say so. The same duty that she had to make sure that the buck stopped with her and that she was comfortable with it, I had the same responsibility. And then I understood what she was telling me from all those years ago, that she was the Justice. She had to be comfortable with it. And I've worked with a lot of smart people during my career, a lot of very hardworking people in my career. And I'm not saying this just because she's in the room. I have never met anyone who tries so hard to get to the right answer, ever. You don't have to work so late all the time, Justice. A little earlier would be nice. But really, it's really amazing. And to see how hard she works it's very inspiring, I have to say. And I've often said that if we could have like 10 RBGs, we had 10 of them, and we could say, okay, this one's assigned to figure out healthcare, and this one's assigned to figure out the deficit, and this one's assigned to figure out the immigration. If we could like sprinkle them throughout the government and just say, look, take the time you need, figure this out, we would be in such better shape. And I say that not for politics, I say it because no one devotes the energy and the mental horsepower that she has. No one. Which makes her, to me, such a unique person. I mean, after all, you know, she like learned Swedish civil procedure, you know, to advance her academic career. if she's willing to do that, imagine if we had her on some of the stuff in this country. So it's very special. I was very fortunate to have clerked for two judges, Judge Wallace in the Ninth Circuit, who's going to be turning 90 this December. And one of the things he taught me was, you could be in this job for a long time. And so you've really got to take care of yourself. And so I want to say, Justice, I have seen the workout in person, all right? It is no joke. She's not going anywhere, all right? She's in great shape. And Justice, I just want to thank you for everything you've done for me and my family. I want to thank you for your service to the country. And Justice, 85 is the new 65. Okay, just remember that. So keep on trucking, all right? Thank you.
What John didn't tell you was that he was on the winning side of that case. Justice O'Connor wrote the opinion, and I wrote the dissent.
It's amazing what she remembers. It's unbelievable.
And just a word about my dear spouse, Marty, who was a superb cook. I was phased out of the kitchen at an early age by my food-loving children. And for all the years we've lived in Washington, D.C., since 1980, I've never cooked a meal. When Marty died, my daughter, who learned cooking from a master, decided that she would take responsibility for seeing that her mother was properly nourished. So she comes once a month, spends the whole day cooking, makes individual meals, which we freeze, and then we do something nice together in the evening. I was delighted when, at the lunch before this session, on the menu was one of my husband's favorite desserts, lime souffle.
So, as Dean Ruder mentioned, I'm from Philadelphia originally. It's really a great pleasure to be back here. Both my parents went to Penn. They tried very hard to keep me in Philadelphia. They plied me with cheesesteaks. But I finally succumbed to New York because New York offered Nathan's hot dogs. And for a good Jewish boy, that was just the right blend of temptation and guilt. But from very early in my days in New York, Justice Ginsburg, who I had not yet met at that time, became one of my great heroes for a number of reasons. The very first lawsuit I ever brought on my own in 1971, just a couple of years out of law school, was representing 4 women who sued the Harvard Club of New York to get them to admit women. And it was an easy case to win because all the theories that we used had already been enunciated by a young law professor at Rutgers, who I had not heard of before that, named Ruth Bader Ginsburg. And she had laid it all out and made my job very easy. When thereafter I became a federal prosecutor, one of the things that I was involved in was the early cases prosecuting inside information. And at first, we didn't have much success in the Supreme Court. They reversed several of the early prosecutions in this area. But finally, an opinion came out that is still the leading opinion in that area, and that showed with great clarity just how insidious insider trading could be. And that was the case of United States versus O'Hagan, in which the majority opinion for the Supreme Court was written by Justice Ginsburg. I then went into private practice at Fried Frank, and of counsel to Fried Frank was Marty Ginsburg. And as has already been mentioned, Marty and Ruth Ginsburg is really one of the great love stories of our time. But I remember asking Marty Ginsburg how he first met Ruth when they were both at Cornell, and he said, well, I met her, I was attracted to her, but she was already dating someone else, but I knew it was no contest because I had a Chevrolet. But Justice Ginsburg's greatest influence, not just on me, but on my colleagues on the federal district bench, have been her opinions over the last 25 years. And not only in the areas that she pioneered, like gender equality, but on a very wide range of areas where her dissents, her concurrences, and her majority opinions have all had tremendous impact. I was going to give an example of the dissent, but of course the example I thought of was the Ledbetter case, and Marcia has already very eloquently described that case, and I forgive you, Marcia. But let me talk about two cases that are more obscure, but very important in my view. One was her concurring opinion in one of the first cases she ever handled on the Supreme Court, Albright versus Oliver in 1994. This was a case involving a wrongful arrest, and the Supreme Court said that it had been wrongly analyzed under the Due Process Clause, and it should be analyzed under the Fourth Amendment as a wrongful seizure, in this case, a wrongful seizure of a person. And that commanded virtually the view of all the justices. But the question that was left open then was, what are the damages? How far does this tort extend? Is it only if the person, as in the case of Mr. Albright, was released on bail right after he was wrongfully arrested? Is that the end of the case and his damage is very limited? And in her concurring opinion, Justice Ginsburg pointed out, I thought very eloquently, how long the effects of a wrongful arrest can last. She said, quote, "A person facing serious criminal charges is hardly freed from the state's control upon his release from a police officer's physical grip. He is required to appear in court at the state's command. He is often subject, as in this case, to the condition that he seek formal permission from the court at significant expense before exercising what would otherwise be his unquestioned right to travel outside the jurisdiction. Pending prosecution, his employment prospects may be diminished severely. He may suffer reputational harm, and he will experience the financial and emotional strain of preparing a defense." And as someone who was myself a criminal defense lawyer for 15 years, that struck so true. So the reality of that was just overwhelming to me. It's interesting, the Supreme Court has never yet to this day decided how far that tort extends, but based almost totally on Justice Ginsburg's concurrence, her view has been adopted by the 2nd, 3rd, 6th, 8th, 9th, and 10th circuits. So there's real impact. The other case I want to mention, and here she was writing for the majority, is Friends of the Earth versus Laidlaw Environmental Services, an environmental case. And this came down in the year 2000. And it involved what some of you may regard as the hyper-technical issue of standing. Believe me, standing is not a hyper-technicality. Standing has been used, I'm sorry to say, by many courts to greatly narrow the degree to which courts can review governmental misconduct. But in this case, Justice Ginsburg confronted an environmental not-for-profit association, Friends of the Earth, who had brought a case against river pollution, a case under the Clean Water Act. And the question below, and the question before the Supreme Court was, did this association have standing to bring this case? And Justice Ginsburg, writing for the majority and convincing judges who had taken a very narrow view of standing in some other cases, said, yes, the members of this association, as they have averred in their affidavits, no longer frequent the area near this river because they can no longer use it for fishing or for picnicking or for camping or whatever. They have real harms, and those are harms that we should recognize and give them standing. And the result of that case is that in the environmental area, one of the most important areas that judges confront, standing is still more broad, more open to significant challenges than in many other areas of the law. And the credit for that, in my view, goes to Justice Ginsburg. Justice Ginsburg is pragmatic. Justice Ginsburg is plain-spoken. Those are virtues that I think appeal particularly to federal district courts. And I know so many of my colleagues regard her as our genuine hero. Thank you.
Let me tell you about a case in which I followed Judge Jed Rakoff. And it was in Venice 2 summers ago. They were putting on a production of The Merchant of Venice right in the ghetto. The day after the opening night, I was to preside at Shylock's appeal from the judgment against him. So I did a little research to see where trials like that had occurred before. And I came upon one at the New York City Bar Association, in which the Honorable Jed Rakoff wrote his decision in rhyme. And he was a pioneer in that Harvard Club case. When I moved from New York to DC in 1980, all of the clubs were for men only. There was the Cosmos Club and the Metropolitan Club. And through most of the 80s, I declined invitations to speak at those clubs. And it wasn't until the very end of the 80s that we saw a wholesale change. So Jed was there at the beginning of a story that has a happy ending.
I'm here as a journalist, and that puts me in a tricky position because technically I think our job as reporters is to discomfit the comfortable, and yet over 18 years of covering the court, it is fair to say Justice Ginsburg has discomfited me much more than I have discomfited her. I find myself constantly grappling with what to make of this person who has taken on this iconic rock chick status in our culture, who is on every tote bag and every T-shirt and every tiny Halloween trick-or-treater who comes to my door, and how to reconcile that with a person who I have watched on the bench for my whole career. And so I'm going to talk a little bit about that, but I'm going to stop and thank Dean Ruger. I'm going to thank this extraordinary panel and thank the Justice for her work. And just to note, as a precatory observation, Justice Ginsburg doesn't know that she more or less raised my children, because when my son was 4 and I was getting constant phone calls from the preschool because he would ritually bite another child whenever I went to DC to cover the court. And it was starting to get frustrating, and at one point I remembered hearing Justice Ginsburg tell the story of how she was always on the hook for her son's behavior, and at one point had to intone to the school authorities, "The child has a father." And that is exactly what I said to the preschool director after the 30th phone call, and they stopped calling me altogether. So what I really want to explore as the journalist, and I suppose the cultural observer of the phenomenon of the notorious RBG, is, as I say, I think this mismatch between the view that we have of her as this fiery, rageful, feminist, radical on the court, and what Marcia described, I think, and just so perfectly, as somebody who is an institutionalist, who is careful, who is a tactician, who never, in my view, ruffles feathers or makes ad hominems when she can speak respectfully and courteously. She always does that. And I mention it in part because I want the record to show that I think we're missing a much better story when we chase the story of someone who is a firebrand. But also, I think more pointedly, because we are at a moment in our culture, the intersection of Me Too and a lot of interesting things happening, where I actually think what Justice Ginsburg has modeled over the decade is actually a much more fruitful and I think thoughtful approach to going forward, even in this moment. So I just want to start with the proposition that it was always said that Ruth Bader Ginsburg was, quote, the Thurgood Marshall of women's rights. And at one level, that was, of course, true. She was doing the work that Thurgood Marshall was doing. But she was so different and is so different from him. So much of his power came from being a raconteur, willing to talk about his own stories, willing to share with his colleagues and with the public what he had seen. And Justice Ginsburg has always, I think, been more careful to use the law itself, the levers and the methods of the law in ways that kind of took her out of the picture in the starkest sense and let the work speak for itself. But also, as I said, I think that it's important to understand that Justice Ginsburg really is and was an institutionalist who reveres the court and the courts and the law in ways that would never have allowed for discourtesy, for burning things down, for burning bridges or breaking relationships. And I think what we see instead, and I think Marcia alluded to this too, is this amazing lifelong jujitsu performance of using the law, often in the early cases on behalf of men. My 12-year-old son loves to hear the story of the thirsty boys, the beer drinkers, who Justice Ginsburg, whose rights that she was trying to advance. Yes, I talked to my 12-year-old about beer. But how that incredibly deft, slow, incremental architecture that was laid out over years and over cases was actually much more effective than grandstanding or drama or burning things down. And I'm going to tell the story, although I think it's unfair, but famously when Ruth Bader Ginsburg was arguing Reed v. Reed at the court, and Justice Blackmun, who would write notes about the advocates, famously wrote of her C+, very precise female. I don't think he understood what a compliment that really was, and that this A+, very precise female, went on to completely change the scaffolding of how we think about gender rights and gender law today. And so I'm going to submit to you that I think when we talk about Ruth Bader Ginsburg, and unerringly, somebody who's watching oral argument for the first time says to me, that I did not expect that. She's very quiet. And I always say, whoever comes into the Supreme Court expecting some hybrid of Emma Lazarus and, Rachel Maddow, someone who's just, angry and throwing their arms around, doesn't understand the quiet power of how Justice Ginsburg does her job. And so while I admire and adore the cult of RBG, and I have all the tote bags to show for it, I also think that the nature of the news media is to reduce the complexity of, I think, someone whose heroism is much more subtle and elegant and institutional, and that the cultural story of what Justice Ginsburg has done in her career is actually much more rich and interesting than our sort of smackdown culture allows for her to be. And so I think what I just want to close on is that we are in a moment where we are dramatically confronted with women's anger and women feeling as though the scaffolding that was supposed to be protecting women has really not supported us in the last years, and that through the magic of NDAs and the magic of conspiracies of silence and power, women have not been able to trust the legal system to afford them all of the rights we thought we had. And I nevertheless would suggest to you that the lessons that Justice Ginsburg modeled and continues to model are the much more powerful and useful lessons about using institutions, about trusting your allies, about making yourself visible to people who don't quite know what you look like, and also listening to them, to other people who you don't quite know their stories, and letting them be visible to you. And that when you use your anger, let it be rare, let it be in Savannah Redding's strip search case, let it be rare, and let it be powerful enough to change minds. And finally, I think what I want to suggest is that going forward, it seems to me that the notorious part of Notorious RBG should be defined a little bit differently. It should be the unbelievably effective RBG. And that, I think, is the legacy that I'd like to celebrate. Thank you.
What Dahlia was kind enough not to tell you about Blackmun's appraisal of my precise argument was Justice Blackmun graded oral arguments. And for that performance, he gave me a C. So my precision didn't have much of an effect on him. I want to say a word about this Marshall comparison, which I don't makes me intensely uncomfortable. Not because I didn't copy his style, that is, taking the court where you want it to go step by step, but because Thurgood Marshall, when he went to a southern town in the morning, he didn't know if he would be alive at the end of the day, and my life was never in danger in that way. And finally, I can't resist telling you the story that Dahlia told you about my lively son. I did get calls regularly from the school to come down to hear what was my son's latest mischievous deed. One day, when I had stayed up all night writing a brief, I was exhausted. I got the call at my office in Columbia Law School, and I said, "This child has 2 parents. Please alternate calls," and it's his father's turn. Well, Marty showed up at the school and was told, "Your son stole the elevator." Marty's response was, how far could he take it? But after that, it's true that the calls came barely once a semester. even though there was no quick change in my son's lively behavior. But the people at the school were much more reluctant to take a man away from his work than a woman. I think that is changing now. One of the things I'm very happy to see is the number of my former law clerks who are now taking parental leave when their child is born. So I thank all the panelists for this afternoon. I thoroughly enjoyed each presentation, and I hope the audience did too.
I would echo those thanks to our panelists, and Justice, thank you for your words. If we do have tremendous student interest in your visit and in your words, we have 5 students who have a question they'd each like to ask, and I guess I would ask you to stand and introduce yourself and ask your question.
Thank you for being here today, Justice Ginsburg. My name is Greta Wiesner. I'm a second-year law student from Minneapolis, and it's an honor to address you. I dressed as you for Halloween last year. So my question for you is, before your appointment as a federal judge, you spent your legal career as an advocate for women's rights. In this role, your goal was to zealously advocate for an interpretation of the law that led to the best outcome possible for your clients and forwarded a cause you deeply believed in. As a judge, your role is as a neutral arbiter and interpreter of the law. Have you ever presided over a case where the law was not on your side, meaning there was no good faith interpretation of the legal doctrine that you believed would lead to what was a just outcome? And if so, what did you do in this case?
I can tell you a category of case that I find trying from the first day I was on the court until this very day, death penalty cases. Now, if I were queen, there would be no death penalty. But I am part of a collegial body, and I could make the decision to stay outside, as Justice Brennan and Justice Marshall did. Their view was the death penalty was unconstitutional in any and all circumstances. If I were to take that position, I would have no part in shaping the law in that area and helping to make it a little better. So I made the decision that I would participate in those cases. When you're a member of a collegial court, there is a strong tug toward a middle ground and away from either extreme. And I think what keeps us from attempting to project our own will is those other 8 on the court. I wouldn't want them to be king. And so I must accept that I am not queen.
Thank you.
Thank you so much for being here. I think I speak for everyone in this auditorium when we say we're truly honored. My name is Carl Anderson. I'm a 2L from Washington, D.C., and I've had the pleasure of sitting in traffic going past the court in the morning on the way to work before. And my question is, as you said in your own words, you have a storied history of taking the court where you want it to go, step by step. But in today's judicial economy, with so many cases getting disposed of either by pretrial motions or in settling, do you still think that test case litigation or impact litigation can be an effective means of civil rights advocacy?
Impact litigation. Well, you heard Marcia describe how anyone who is interested in changing things to make them a little better proceeds. The first is you must have people on your side. So public education, public information is the beginning. A legislative solution is always desirable if you can get it. And I would put the courts third as audiences for change. Courts are reactive institutions. They don't have an agenda of their own, unlike the political branches of government. So I would say for someone who's interested in social change, gather friends around you. There is truly strength in numbers in that regard.
Thank you so much.
Hi, I'll echo everybody's thanks so much for being here. It's an incredible honor. My question is, how do you think the Me Too movement might affect the court's perspective on Title VII sex discrimination cases in the future?
How do I think the Me Too movement? Let me start back in the 70s. I received from a publisher a manuscript of a book titled Sexual Harassment and the Law, written by a woman named Catherine McKinnon. It was eye-opening. It suggested that Title VII, our principal anti-discrimination in employment law, could be used to redress sexual harassment. And the court in the 70s decided a few cases agreeing with Professor McKinnon that, yes, sexual harassment is a violation of Title VII. Well, the law is one thing. The practices of people is another. And this phenomenon that we're seeing is something that has finally gotten its due. I do hope it will not be just Hollywood stars and other prominent people, that it will go down to the maid in a hotel. But I am hopeful that this movement will succeed in stopping something that should have been stopped a long time ago.
Good afternoon, Justice Ginsburg. It's a pleasure to have you here. Tremendous honor. Thank you so much. My name is Ebenezer Jesse. I'm a second-year law student from Newark, New Jersey. On campus, I have the privilege of serving on the boards of the American Constitution Society, the Federalist Society, and the Black Law Students Association as well. My question for you is that in an interview conducted with BBC last year, you stated that the true symbol of the United States, it's not the bald eagle, it is the pendulum. And when the pendulum swings too far in one direction, it will go back. I guess I'm wondering, besides historical practice, can you talk a bit about some specific things that make you confident and optimistic about America in the long run?
I have lived a long time, and what I have seen has made me optimistic about the future. Let me tell you about my days as a university student, and they were dark days for our country. There was a huge Red Scare in the country, and Senator Joe McCarthy in the Senate and like-minded people in the House were calling people before congressional committees to justify their membership way back in the 30s in some socialist organization. We got over that period, and Senator McCarthy ended up a disgraced man. what signs do I see of optimism? Well, I see the millennials who are not sitting back and just taking it. And my faith is in you. I was very encouraged by the Women's March in DC. And that I think it is not a one-time phenomenon. We are already seeing it repeated. So it's in your hands to see which way our country goes, whether it will adhere to its most basic values or whether it will succumb and suppress our right to think, speak, and write as we believe and not as a big brother government tells us we should. That will continue to strive to make our nation a more perfect union by being more inclusive, more embracive of all people. I think the strength of our country is its diversity.
Thank you very much.
Thank you, Justice Ginsburg. My name is Alex Patrick. I'm a second-year law student. I'm from New Jersey, and it is a distinct privilege to be speaking with you today. You and the late Justice Scalia had a long-lasting friendship, despite some ideological differences. Given the country's current climate, a culture of division and deadlock, we need models for compromise and mutual respect now more than ever. How do you and your fellow justices work together despite disagreements and differing views? What is the approach of the Supreme Court, and how can we take that outside of the law context?
About my dear colleague, Justice Antonin Scalia, like you, he was born in New Jersey, although he was bred in Queens, New York. A collegial body must have mutual respect to work effectively. And the Supreme Court of the United States is the most collegial place I have ever worked. We have some customs that help promote that collegiality. Every day before we sit and every day before we confer, the first thing we do is we go around the room. Each justice shakes hands with every other. It's a way of saying, yeah, yesterday you sent me that nasty dissent. But we know we're all in this together, and we have to, as Scalia would say, get over it. We celebrate birthdays. The chief will bring in some wine, and we'll have a happy birthday chorus. We have 2 musicals a year. I'm particularly proud of those because I'm in charge of them. Each justice gets 6 invitations, and it's a very popular event. When a new justice comes on board, the person who is then relieved of the job of being the junior justice hosts a dinner to welcome the new member, as Justice Kagan recently did for Justice Gorsuch. We travel together, sometimes stateside, sometimes abroad. So I have been with my colleagues to meetings in London, where I was with Justice Gorsuch when he was Judge Gorsuch, with Justice Scalia, Justice O'Connor, Justice Breyer, to the European Court of Justice, which is the highest court of the European Union, to the Human Rights Court in Strasbourg, where we do try to learn about other systems of justice. As I said, collegiality is essential in our workplace. And with Justice Scalia particularly, what I loved so much about him is he could make even the most sober judge laugh. He was a very funny fellow. And when we were together on the DC circuit, he would sometimes whisper something to me during an argument, and I had all I could do to avoid bursting out into hysterical laughter. We are also keen on families. We had an annual New Year's party where my children and whatever Scalia children were around would celebrate together. Justice Scalia and I shared a love of opera. And among my fondest memories, we were supernumeraries extras at the Washington National Opera a few times. We would comment on each other's opinions, and sometimes I would tell him privately, "This is so strident, it'll be more persuasive if you tone it down." He didn't take that. But he would come to me, either he'd call, come to my chambers, to tell me about a grammatical error I had made. He was very gentle in doing that. He never circulated to the full court to show my error. So just recently, at the Library of Congress, there were selections from an opera. Did you know that there's an opera, Scalia Ginsburg? It is, of course, a comic opera. And members of the Senate and House Judiciary Committees said that they were interested in this. So could we have some excerpts from the opera? It was a great evening, and it starts with Justice Scalia's rage aria, which goes like this. "The justices are blind. How can they possibly spout this? The Constitution says absolutely nothing about this." And then I answer him in my lyric soprano voice. "You are searching for bright line solutions to problems that don't have easy answers. But the great thing about our Constitution is that, like our society, it can evolve." The plot goes on. Justice Scalia is locked in a dark room, being punished for excessive dissenting. And I enter, it's a little hard to stage this, but I do enter through a glass ceiling. And I come to help him go through the trials he must pass to get out of the dark room. The man in charge of well, those of you who know opera will see that the plot is roughly based on the Magic Flute. But there's a character brought in from Don Giovanni, the commentatore, and he is astonished. He said, "Why would you want to help him? He's your enemy." And I respond, "He's not my enemy. He's my dear friend." And then we sing a duet. and it is, we are different, we are one. Different in our approach to the interpretation of legal texts, but one in our reverence for the Constitution and for the institution we serve.
Thank you.
Thank you, Justice. Thank you to the panelists. This has been so educational and inspirational. I think we all learned so much. Thank you for your wisdom and for being here with us. And I also really appreciate the panelists' remarks, the tremendous questions from the students. Justice, we are so proud to have you here with us this afternoon. Thank you. I would ask, as we close with applause, for the audience to remain seated while the Justice departs. And this has been a great session. Thank you.